Question 38. Which statement is a true statement regarding radon gas? Florida law requires that radon testing for homes built prior to 1978. Brokers should consult radon level maps when advising buyers regarding radon testing. Florida law requires mandatory radon disclosure before or at the time a person enters to a contract for sale and purchase. Or D, sellers are required to install radon gas remediation equipment if unsafe levels of radon gas are present in residential property. C, simply, it's just a disclosure you must disclose. Answer A sounds good, but answer A actually is required for lead-based paint. If the property built, residential properties built prior to 1978 would be lead-based paint. That's the lead-based paint disclosure. 39. A married couple filing taxes jointly has sold their residence for a substantial gain, which is not correct about their ability to exclude the gain from their taxes. A, they must have occupied the residence for 2 of the last 5 years. B, they may exclude up to $1 million of the gain. C, the ownership and use periods need not have been continuous. D, they may exclude up to $500,000 of the gain. B. That correct answer is B. Even if a student was just guessing, by process of elimination, you cannot have B and have D. Either they can exclude $1 million or they can exclude 500, but the answer can't be both. But the correct answer obviously is this is a not question. So the truth of the statute says they can exclude 500,000. So that makes being able to exclude $1 million incorrect. In the federal tax law, married couples can exclude up to 500,000 of their gain. Single couples can exclude 250,000. Right. Okay. 40. Last year, a brokerage had 220 sales. After paying sales commission to the associates, the company had 325,000 remaining. The firm's monthly expenses are budgeted at 29,000 for next year, with the goal of 19,000 monthly profit. Assuming no change in the company dollar percentage, how many transactions must the company have each month to meet its goal?
32.
32.
You see?
I see you're a wizard with math. Do you have your calculations or you just?
I did the calculations.
Okay. Could you explain your calculation that you did?
I took the company's yearly income, $325,000, because they said nothing was going to change. I divided that by 220 sales.
And that comes to, you got that number?
I don't have it.
Okay.
Then I wrote down, then I added the $29,000 budgeted for the next year's monthly expenses to their goal of 19,000, which came up to 48,000, and I divided that by the sum, which I think is like 1477.27. I divided it by 1477.27, which came out to 32.
Okay. Remember on the honor system, but that sounds right. Okay. And I'll but great answer. And my philosophy with math, just in general, know the concept. If you know the concept, you have a shot. So a lot of students, if they don't know the concept, they don't have a shot. And even if you know the concept, different students have different math proficiencies, or you could just simply hit the wrong button on your calculator. But that's a great answer. And this is probably one of the toughest concepts mathematically that a student will be tested upon. But obviously, looking at it from a broker perspective, this is basically, I'm not sure which chapter this comes out of, brokerage, but basically looking at it from a brokerage perspective, it says, looking at it from a brokerage perspective, chapter 3, owning, managing, and supervising a real estate office. This is a budgeting technique to determine sales volume and your profitability of your given brokerage firm. 41. Broker runs ads in the newspaper that describes the company's history, quality of service, and the expertise of sales associates. This is A, product advertising, B, specific advertising, C, institutional advertising, D, the rifle approach.
D,
institutional advertising. Okay.
Did you say what?
D.
So I was wrong.
I'm sorry. Your answer was D, the rifle approach?
Yeah.
Okay.
Because the rifle approach says that they give a lot of information, right? In reference to the specifics of the company. And so
Good
if they're
job.
giving the history and the quality and the service and the expertise, I would assume, but I guess I assumed wrong.
Right, it's the institution, you're giving the institutional background of that respective organization.
Got it. It makes sense.
And that would be in chapter 3, again, part of owning, managing, and supervising the real estate office, dealing with the advertising functions of that office. The previous question dealt with, but more so budgeting and projections for profitability, and this deals with advertising. 42, in lien theory states, the lender has the title to the property and the borrower has a lien. B, the borrower has title to the property and the lender has a lien. C, the lender has equitable title but not legal title to the property. D, the lender or trustee has legal title to the property until the mortgage is paid. B, exactly. And I know you have a mortgage background prior to your real estate background. Basically, the mortgage serves as a lien against the property in lien theory states. There's two types of states: title theory states, lien theory states. Florida's a lien theory state, where the mortgage serves as a lien against the property until it's fully paid. But the borrower has title to the property from day one, from the day of closing. 43, an unwritten contract is A, unenforceable, B, a parole contract, C, not valid for listings, D, always executory. Have to slow down and say that word. Your answer was B, a parole contract. Exactly. The way you remember is oral patrol. Oral contracts are legal, and up to 4 years is statute of limitation for their enforcement. Real estate contracts must be in. The statute of fraud says the real estate contracts must be in writing, however. For oral contracts or parole contracts, not for real estate conveyance of real estate, but they are legal for business arrangements and can be upheld. I believe in key numbers we mentioned 5 years. No, we didn't, but I think we mentioned 5 years. The broker must retain their records of contract because the broker is going to have a written listing agreement, things of that nature. Also in those key numbers, 4 years for oral or patrol contracts. That's how long they are enforceable. Okay, so
could an unwritten contract be unenforceable though, also?
If it's illegal, a lot of ways contracts can be unenforceable, but generally, unwritten contracts, they could be. I mean, if it's better, obviously, to get it in writing. An unwritten contract, the answer to your question, would be unenforceable if it's one for the conveyance of real property, because all real estate things must be in writing. All conveyance of real property, where you're conveying title, must be in writing, and that's what that statute is called the statute of frauds, which states that all real estate contracts that convey title must be in writing. So in that case, you can't have an oral contract for someone to sell their property. But you could have an oral contract for a variety of other things, which transcends from real estate, but just, I'm going to sell you some computers, I'm going to sell you this, or whatever. Someone makes an offer, someone accepts it, consideration is given, it's not in writing, it's oral. Yes, that's why the answer, well, they want to know what is it. It's not unenforceable. The answer is a parole contract. It's a valid contract. Parole is the same as oral. And their statute of limitation to sue someone or make a claim against that contract is 4 years. So great question. I got to put aside. So we're almost there with, I think we're 7 questions away. And we'll take a pause and we'll go to the next batch of questions.